thank you all for listening to all of this here today. I think what's important to realize is that the facts of what happened. I mean, you'll hear a lot from attorneys, you'll hear a lot from me, and take what I say and take what opposing counsel said with just a little bit of a grain of salt, and realize that on some level, a lot of times, attorneys are trying to help their clients, and they're going to try to distract from the actual issues to try to get some sort of outcome that's desirable. In this situation, that is all that Chuck Harris has. If you look at, think about this holistically. If you're going to be arguing about the Constitution, if you're going to say, look, the Constitution's what rules here, it's all about the idea of equal treatment and freedom of speech and freedom of association, then you heard the Republican Party chair. She said, very openly and clearly, they don't want Chuck Harris on the Republican primary ballot. He's not on the list, he wasn't qualified, the convention voted him not to be there. It would be atrocious for the government to say that the Democrat Party has to support Donald Trump. It would be atrocious for the government to say the Democrat Party has to qualify some Trump supporter to run in this county as a Democrat. That wouldn't be right, that wouldn't be fair. The other side is mocking civil rights law. Every time they're saying, well, you need to be treated equally. Equal disparate treatment, that's talking about race and sex discrimination. It's not talking about political parties. Political parties have a right to associate with people who support their platform. That's the point of the political parties, is to get your platform enacted. The Republican Party doesn't want Chuck Harris because Chuck Harris isn't supporting the platform. Rightly or wrongly, that is what came out of their convention. So if you're arguing about the Constitution, you're going to say, we're going to stand by the Constitution, then he shouldn't be qualified. But I understand there may be different opinions on that. People may think that, all right, we got to follow the law. The rule of law, which I think Democrats and Republicans all agree on. The rule of law is what has been presented to you today by us. You look at the law, you look at what is in the statute, and you walk through it. You have in there is no requirement in the law that there be a packet. There's no requirement that the Republican Party provide anything to candidates who walk in. That isn't in the law. What's in the law is 21-153. This is if you're ignoring the constitutional argument. It says that no person shall be prohibited from qualifying for office if he or she, and it lists off 4 things, and one of them says, if party rules so require, affirms his or her allegiance to his or her party by signing the following oath. Quote, I do hereby swear or affirm my allegiance to the name of party, in parentheses, party, which would be affirm my allegiance to the Republican Party. That is what is required by the law there. The act of qualifying in 21-154, that involves the county executive committee certifying to the superintendent, which is you all, on forms of the Secretary of State, all those candidates who have qualified. And then it says that any candidate whose name doesn't appear on the list shall not be certified. His name wasn't on the list, period. You look at 21-284, all candidates who have qualified with a party in accordance with this chapter and party rules, and who have been certified with the superintendent, which is you all, shall be printed on the ballot. It's not qualified with them, and it's not in compliance with the rules. Now, they're trying to make this argument that somehow the party did something weird, and Chuck Harris, who's an elected official who makes laws, who should know the laws, and this is something that is in the evidence. You don't have to believe me for what I'm about to say. You can just look at the complaint that was brought in, that on the top right corner, it's file stamp. There's a little file stamp up here in the top right corner showing when this lawsuit was filed. It was filed on March 5th, 2026. That is the Thursday of qualifying week. If you look down, you'll see Chuck Harris's counsel's name there. He was involved in this at the time. So they filed a lawsuit on Thursday. Attached to that as a sworn statement, if you flip all the way to through it, it talks about the documents that were submitted. In the complaint itself, it says that certain documents were submitted. This is a sworn complaint. There's a verification, meaning that Chuck Harris swore under oath with this. One of the attachments to that document is Exhibit B, which shows a declaration of candidacy and affidavit. And just actually, Exhibit B shows all the documents that were submitted. And if you look there, since opposing counsel made this very clear, if you look at the notary stamp on that document, on Exhibit B, that was attached, it was filed on the Thursday. you'll see that the notary there is from Murray County. Nobody from Catoosa. This document was obviously not notarized at the Catoosa County GOP headquarters. He showed up with the document. And if you look at the second document that is signed, that was also notarized in Murray County. So whatever documents that Chuck Harris claims that he submitted and were so important, he came in with them. He showed up. He had done research ahead of time. This is not me making up something. This is obvious from the evidence in front of you that's been filed into the court records. So that is what Chuck Harris did. And then if you flip back even further, I believe it is Exhibit C. Yes, Exhibit C to that was filed in the court. And you go to the second page of that, those are the part of the Georgia Republican Party rules. And they're like, well, I don't know about the oath. I didn't know about the oath. We had no idea about the oath. This oath must be hidden somewhere. Well, other than the testimony you heard from Joanna saying like, hey, it was on our website, and the fact that you all know that it's not hidden, because the Republican Party rules for the county are on file with you all, you look at what was attached to this complaint from Chuck Harris that was filed in court. The second page there, Exhibit C, from the Republican Party rules. Any candidate for elective office running as a Republican Party candidate shall submit to the appropriate level of the party, in this case this would be Catoosa County, the following oath affirming his or her allegiance to the party by signing the following oath. Quote, I do swear or affirm my allegiance to the Georgia Republican Party. It's in the rules. He had a copy of it. He filed it in court on Thursday, and he didn't sign it, and he didn't submit it, and he knew it, and his attorney was there and should have known it. Mm-hmm. So the argument that you are hearing from them is one of just appealing to sympathy. You're like that somehow because he's not liked, he should somehow get special treatment. Ignorance of the law is no excuse. This is a lawmaker who had an attorney on the Thursday before qualifying was done. And a couple questions that were asked in a soliloquy by opposing counsel was like, well, why did others get cut? Well, it's not the Republican Party's fault that Mr. Harris didn't have the right paperwork, and it's also not the Republicans' fault they didn't have friends or an attorney who told them about this in the law. Like, it's not our obligation in the Republican Party or Mr. Fant's obligation to do that. It seems like they're talking a lot about what the party did, but the issue here is that did Chuck Harris do the things under the law and the party rules which are required? And he didn't. The party rules are in front of you. You've seen them. You know them. Looking at the law, Mr. Fant has brought up he didn't qualify, he didn't comply with the law, he didn't comply with the rules. Mr. Harris has not complied with the rules. He didn't submit the Republican Party oath. Maybe he could be an independent. I don't know. I don't know if you all would want to do that. All I have to say is that he obviously did not comply with the rules and challenge to be upheld. And also the question about whether or not he's correcting. He could have corrected. He was in the office reviewing this paperwork. They're trying to say that somehow something happened with paperwork. There's no evidence they submitted a loyalty oath at all that's required by the law and the rules. And the idea that there's a First Amendment right by Mr. Harris, I mean, he could run for office. He just isn't qualified with the Republican Party. And that's the underlying point here. So thank you all very much.